SMU constitutional law professor Dale Carpenter. Thank you so much for joining us. We're talking about the Supreme Court's order, which essentially, it was a 5-4 split decision, which essentially allowed the Texas Fetal Heartbeat Act, the law, to go into effect. They are not going to intervene. So first, your reaction to this, and on what basis did the majority of the court make this decision?
The court made this decision solely on grounds of procedure and jurisdiction, and solely on an interim emergency basis, so that it had nothing to say about the merits of the constitutional argument against this Texas anti-abortion law, and it's reserving that question for another day.
And it's that, when you read some of the dissents, and certainly the dissent from Justice Sotomayor really stands out. She was very vocal about her dissent. She said, basically, she called the order stunning. She said the majority of the court buried its head in the sand and silently acquiesced in a state's enactment of a law that flouts nearly 50 years of federal precedent. She's basically saying the court is allowing the state to violate the Constitution and Roe versus Wade. Is that what she's saying, essentially?
Yes, she's saying that, and I think the other dissenters can fairly be read to say similar things, although less strongly. And she's saying that Texas has managed to insulate itself and its law from judicial review, at least on this short-term basis.
Can you explain that? Because a lot of people are wondering how that is so.
So what happened here is that the law was challenged by abortion providers against a number of different defendants. The Fifth Circuit interfered with their ability to actually challenge the law, at least on an emergency basis, before it went into effect. So they immediately went to the Supreme Court on an emergency basis. And that's an extraordinary thing for the court to interfere on an emergency basis in an ongoing set of litigation. So the court really had a difficult time with the issue, I think. And because the issues were so unprecedented, especially the way in which the Texas law is being enforced is unprecedented, that they just decided to wash their hands of it for the time being. And then let the lower courts make their decisions, make their determinations, have full briefing at a later time, and then come back to the Supreme Court if necessary under an appropriate procedural posture.
And so just on that point, because there's so many other questions to ask, but just on that point, legal challenges are still going to be able to be filed. I mean, this particular case will go back to a district federal court here in Texas. Is that right?
That's right. So legal challenges are still very much alive. The only question on the table for the Supreme Court is, are we going to act and act now? And the court said no. But that does not prevent lower courts in the future from acting to enjoin the Texas enforcement of the Texas law. And by the way, it doesn't stop state courts from acting and litigation from being filed in state courts.
So this could have multiple avenues and multiple courts.
Once again, yes.
And it doesn't prevent the Supreme Court, the US Supreme Court, from ultimately making a decision on this case.
That's correct. So we've got two tracks of litigation, one in state court, one track in federal court. There could be multiple filings in each of those different tracks. And then, of course, there are levels of appeal. And there are appeals courts for the state, appeals courts for the federal courts, and of course, ultimately, the Texas Supreme Court, and then finally, the United States Supreme Court for the federal track.
And let me go back to a point you made before, and that is the US Supreme Court's historical passed as far as it relates to intervening on an emergency basis. Are you saying that the court rarely does that, if ever?
It rarely acts on an emergency basis. It has done so, and it has done so indeed in the past year during the COVID crisis, when you may remember some religious groups challenged application of some COVID restrictions to religious gatherings. The Supreme Court has actually acted to protect those constitutional rights on those emergency orders. It did not do so in this case. I think for the court, there was a very complicated set of issues here that it just did not want to resolve quite yet. And that's caused it to say, go back to the lower courts, we'll decide the merits of this issue later.
I mean, because in the majority ruling, it said, I mean, it listed some reasons, but one of the sentences that stuck out to me, and I'm not an expert in this, you are, it said the sole private citizen respondent before us has filed an affidavit stating that he has no present intention to enforce the law. In light of such issues, we cannot say the applicants have met their burden to prevail in an injunction or stay application. So, I mean, talk to me a little bit about what they mean by that.
Well, so there were two different sets of defendants that were sued in the lower courts. There were government officials, namely judges in Texas and clerks in Texas in those courts, who have to actually docket or file any kind of attempt to enforce the Texas law. And then there was this private individual associated with a Texas Right to Life movement, who says that he doesn't have an intention now to file a lawsuit. All the Supreme Court, I think, said is that right now, in this short period of time, that's going to be enough for us to say we're not going to act on an emergency basis. But if the Texas law is actually enforced in the future, you would certainly have the ability to come back to the court and say, okay, now we're getting enforcement, and we ought to be able to actually have the merits heard, and maybe the Supreme Court would act at that time. Just wasn't quite ripe for the court.
Go ahead. I'm sorry.
You know, the thing about litigation in the federal courts and even in the state courts is it's not enough just to have a complaint and a real substantive merited kind of basis for proceeding. You have to have the right parties, which means the right defendants and the right plaintiffs, make the right kinds of claims, and then do so at the exact right time, not either too early or too late for a court to even hear the merits of the claim. So essentially what the court was saying is, we're not sure whether you actually have the right defendants here. We're not sure about that. You might have the right claim, namely the right to abortion, but it's probably too soon.
And in his dissent, the Chief Justice, Justice Roberts, called this an unprecedented law. And he said he would have granted a stay so that the lower courts, district and court of appeals, would have the time to actually go through this. And he would give that time because this is unprecedented.
It is unprecedented. And what the Chief Justice said in his opinion, it's notable, by the way, that the Chief Justice, one of the 6 conservatives on the court, was actually with the dissenters in this case. So who knows what that says about the future. But he said what the court ought to do right now, even on an emergency basis, is to preserve what he called the status quo ante. That is the status quo that existed before Senate Bill 8 took effect. And that status quo was one in which women's right to abortion before viability was protected.
So what is the immediate impact now? This law goes into effect. What's your thought about that?
Well, so it's possible that some citizen could now file a lawsuit in a Texas court claiming that an abortion provider or someone else has helped an abortion to take place in violation of the law, one that was basically before after the 6-week period. That's possible. But we don't know that that's going to happen, or where it's going to happen, who would bring that lawsuit, or against whom. You've got potentially millions of plaintiffs and defendants out there, not even limited to the state of Texas. So who knows where and when that's going to happen. But I can tell you the immediate effect is what we might call a kind of interorum effect. That is to say, it has really put fear into abortion providers, and not just the clinics, but anybody who works for the clinics or anyone who assists a woman with an abortion. It's really put fear into them that they will be subject to litigation, and even having that fear out there that you could be exposed to liability and have to hire lawyers and go to all of that expense and then have a $10,000 fine assessed against you. That is having an effect apparently on these abortion clinics who, at least for now, have decided they're not going to go forward with abortions in violation of this Texas law. That's an immediate effect without one lawsuit ever having been filed.
And I would imagine that's by the law's design.
By the law's design. And in fact, it may mean that some clinics are going to have to close.
And let me ask you, let's talk about this law, because when you look at some of the dissents, these issues were brought forth, and certainly by opponents as well. One provision is that a heartbeat has to be detected. A doctor has to check to see if there is a heartbeat before performing an abortion. And if there is one, they won't be able to perform the abortion. And that can be, a heartbeat can often be detected at 6 weeks, often before women even know they are pregnant. Compare that to what Roe versus Wade upheld and allows. So this is obviously very different than what federal law says is allowed.
That's right. Roe versus Wade said that women had a fundamental right to choose whether to have an abortion or carry their pregnancies to term before the point of viability. That is the point at which the fetus could live outside of the woman's body. Before that point, the state cannot ban abortions under Roe versus Wade and under a subsequent precedent called Casey in 1992. That's at about 23 or 24 weeks of pregnancy. That's not 6 weeks of pregnancy. So the conflict between this Texas law and Roe versus Wade is very clear.
And so how, now the way that this law is written, as I understand it, and what a lot of people have commented on and what we've reported on, is that the state is not the one that enforces this. The private citizens, as we've discussed, are the ones who can file civil lawsuits against any provider or any related person in that matter. And so is that the way that, you know, the state escapes it, for the simple reason that private citizens are doing this and not a government entity?
Well, so that's an interesting question. I think what Texas did by design was try to frustrate challenges to the law. The law itself actually does say that abortions after the point of about 6 weeks of pregnancy, as you indicated, does say that those abortions are not permitted. They are prohibited. But the enforcement mechanism is through these private citizens who anyone can sue if they learn that there has been an abortion after that point. Ordinarily, constitutional provisions restrain only the government from acting. So typically you would have law enforcement officers enforcing a criminal law, and then the criminal defendant might say, well, that law is unconstitutional, so I can't be confined to prison or convicted under it because it's not effective, it's not legitimate. Here, we don't have enforcement by the government, we have enforcement by private citizens. I don't think that in principle that such a law would be regarded as constitutional. So if the government cannot veto a woman's decision to have an abortion prior to viability, it also can't transfer or delegate to someone else the power to veto a woman's decision prior to the point of viability. The one prohibition entails the other.
Well, yeah, I mean, Justice Breyer said in his dissent that it really shouldn't matter whether it's, whether the state is, transferring its power to citizens because the law threatens to evade a constitutional right. Talk to me a little bit about that, because isn't part of what any court is going to have to decide is whether a state can essentially outsource the enforcement of its own laws to private citizens.
So substantively, just as a matter of the substance of the constitutional right and the imminent threat to that constitutional right, substantively, Texas's law is unconstitutional under Roe versus Wade, existing doctrine. Procedurally, there's a difficult question about whom one sues and tries to prevent enforcement of the Texas law. Who does one sue? You've got a potentially almost limitless number of people who might enforce this law. Who do you sue? Who do you sue on behalf of? Because you've got, as I mentioned earlier, 7 million women of childbearing age in the state of Texas who might all be subject to this kind of restriction. So it's it's kind of unwieldy for courts to deal with this when you've got an almost limitless number of plaintiffs and defendants. Courts are used to having a clear plaintiff and a clear defendant and a clear issue brought at the right time. We have almost none of that right now. And so where Texas has succeeded is not so much in the substance of constitutional law, which is clear, the law violates the Constitution, but it has succeeded, I think, for now, in throwing up a procedural hurdle, not a substantive hurdle, but a procedural hurdle to actually getting that constitutional right fully enforced.
And so what do you think what would a judge or a court have to do to determine whether this procedure is enough to, make it permanent and let the law stand, or determine that it's unconstitutional?
I think for the challenge to the Texas law to be successful, the plaintiffs are probably going to have to get an injunction against a very broad class of possible defendants, including maybe all of the clerks in Texas, the judges in Texas, maybe the organizations like Texas Right to Life and others, and maybe individuals who are seen as likely to try to enforce the law, to do as much as they can to get a broad sweeping injunction against them, and to have a declaration in federal court, or perhaps in state court, but more likely in federal court, that the Texas law in substance is unconstitutional. If you can get that declaration, that could dissuade any future attempts to enforce the law by private parties. It could dissuade them from trying to do so, because their efforts will be futile at that point, because they'll have to pay their lawyers, and they won't get their $10,000 bounty, and they won't get injunctions against abortions.
And what would the U.S. Supreme Court have to decide in that case? Because I know in talking with you, one thing I've learned is once it gets to the Supreme Court, it's not about the facts of the case, it's about the law itself.
Yeah, so there are some difficulties, I think, in getting a case before the Supreme Court. The initial immediate difficulties are jurisdictional difficulties. That is, does the court have the power to decide the particular challenge to the Texas law. And those involve very complicated doctrines of things that are known in constitutional law as standing, of rightness and mootness and sovereign immunity. Usually you can't sue a state or state officials in federal court. All of those are difficult questions that a court would need to resolve. So those will be some of the things. Those are threshold procedural or jurisdictional issues. The substantive issue, again, the merits, as long as Roe versus Wade is around, as long as it's effective, as long as it's not overruled, the substantive issue is actually not difficult.
Okay. And so you're saying, are you saying that the procedural hurdles would have to, once that's found in the lower court, then that clears the way to get to the Supreme Court?
Possibly, yes. I think that's the way this could end up ultimately in the Supreme Court, and or more than likely, the Supreme Court would just say, well, if a lower court has entered an injunction and it's done so properly, then we're not even going to hear the dispute from the state of Texas or whomever the defendants turn out to be.
Now, this comes as the top court is going to take up a Mississippi law. And what's the issue there? Is that really just whether Roe versus Wade is constitutional?
So the Mississippi law is somewhat less aggressive than the Texas law, but it's no less in conflict than with Roe versus Wade than is the Texas law. So the Mississippi law prevents abortions after about 15 weeks of pregnancy. Again, that's still within the period before viability when women have a right to abortion under Roe versus Wade and Casey. So the substantive issue in that case is also pretty clear. I think a couple of things, though, could happen. One is the court could decide, and Texas is actually arguing it should decide, that Roe versus Wade is going to be overruled. Or it could decide that Roe versus Wade is in some fashion going to be pared back to allow more state regulation.
Let me ask you just a couple of other questions, and I appreciate your time. And that is, talk to me a little bit about, I believe during hearings in Congress before someone who was appointed by the president before in their confirmation process, they're always asked, is Roe or what about settled law? So how big of a decision is that for the court? Is this settled law after what, 50 years?
Well, Roe versus Wade, I think the defenders of Roe versus Wade would argue that it is entirely settled law. In fact, it was reaffirmed in a number of decisions, including in 1992 in that case called Casey versus Planned Parenthood. So they would argue that it is very settled law, that women have come to expect that they will have the right to abortion, and they've relied on the right to abortion. It would be hugely upsetting to our constitutional rights for the court to overrule that decision. I think opponents of abortion rights would argue that Roe versus Wade was so weak as a matter of constitutional doctrine and had no place in the Constitution, and isn't really settled because it's continually challenged by the states and in litigation, and it's been eroded over time, that it's not settled anymore, and the court ought to just get out of this area entirely. The court has occasionally overruled long-established precedents. Those have usually been precedents that denied constitutional rights, not precedents that affirmed constitutional rights. So a decision to overrule Roe versus Wade would be a monumental decision. And I think in some ways we are seeing a preview of the kind of confusion and the dislocation and disruption that overruling Roe versus Wade would entail in Texas, where you suddenly have long lines for women trying to get abortion procedures before a deadline. You have women being told to go out of state, some of whom can't afford to do so. You have clinics being shut down. We're seeing some preview of that if the court ultimately moves in that direction.
And let me ask you, a question was asked yesterday at the White House press secretary briefing about this issue, and her reply was codifying Roe versus Wade. And the Congress hasn't passed a law that would codify Roe versus Wade. If they were to do that, would that override the state law in this case?
If they were to do that, and depending on what this codification of Roe versus Wade actually said, then the answer to that is yes. The Congress does have the power to enforce the Constitution's protections of fundamental rights under the 14th Amendment. So if the Congress decided to enforce in an appropriate law the substantive constitutional protections, then it could do so. That would not help Congress if the court, that wouldn't help actually abortion rights advocates if the court decided to overrule Roe versus Wade, because what Congress has given the authority to do is enforce the Constitution, not to go beyond the rights guaranteed by the Constitution. So if the court said abortion is no longer a constitutional right, there would be no codification of Roe to be had.
So what you're saying is Congress would have to act fast.
Congress would need to act, and I think it would need to act in a way that was comprehensive enough to cover not just a threat to Roe versus Wade from state officials, but also from what Texas has done in this case, private parties that seek to challenge a woman's right to abortion.
And then let me ask you one final question, and that is, today, President Biden blasted the Supreme Court order, but he also said that he is directing the Gender Policy Council and the White House Council to launch a whole of government effort to respond to this decision and look specifically to the Department of Health and Human Services and the Justice Department to see what steps the federal government could take to ensure that women in Texas have safe and legal abortions as protected by Roe versus Wade. What do you make of that?
Well, it's hard to know what to make because we don't know what those actions might entail. Maybe the Biden administration is thinking about potential civil rights actions against Texas. Maybe they're thinking about funding, withdrawing or conditioning funding for Texas in light of the enforcement of this Senate Bill 8. It's hard to say exactly what they might have in mind, but they would have to be within some statutory power or other inherent power given to them under federal law or the Constitution.
SMU constitutional law professor Dale Carpenter, thank you so much for all the time and insight you provided for us today. Thank you.